Marcus has lived in Australia for 10 years, but his legal standing is precarious. He currently holds a bridging visa C, and his immigration history is marked by two significant setbacks: a refused partner visa from years ago and a refused protection visa. Since those refusals, his life has changed. He is now married to an Australian citizen, and they are raising a 1-year-old child who is also an Australian citizen. Under standard migration principles, these family ties are often seen as a clear pathway to permanent residency. Logic suggests that a new onshore partner visa application should be successful, based on the genuine nature of his marriage and the interests of his child. However, under current Australian legislation, Marcus cannot validly lodge this application. The legal framework prevents the Department of Home Affairs from reaching the stage where they would even examine his marriage certificate or his child's status. This case highlights a reality in Australian migration law. The strongest compassionate grounds are ineffective if the applicant is barred by specific statutory requirements at the very start of the process. To understand why Marcus is blocked, we have to look at the order of operations for any visa. In administrative law, this is a strict two-step chronological process. Step 1 is validity under Schedule 1, the doorway checking your history and paperwork. Step 2 is assessment under Schedule 2, where a delegate evaluates genuine relationships and compassionate circumstances, like the Wanasila precedent, where having an Australian child acts as a compelling reason. The difficulty for many applicants is that they focus entirely on building their case for this second step, not realizing that the law requires them to pass the validity gate first. Returning to Marcus, we see why he never reaches that second room. The first hurdle is Section 48 of the Migration Act. Because Marcus is in Australia without a substantive visa and has had a visa refused since his last entry, Section 48 places a statutory limitation on him. He is legally restricted from applying for most other visas while he remains on shore. There is a specific list of exceptions under Regulation 2.12. This list includes partner visas, which often leads applicants to believe they have found a way around the Section 48 bar. But the validity requirements in Schedule 1 contain a hidden condition. Under Item 1124B, if you are subject to Section 48, you can only apply for a partner visa if you have not been refused certain visas in the past. Specifically, the law excludes anyone who has previously had a Subclass 820 partner visa refused. Because Marcus had an 820 refusal 10 years ago, his new application fails the validity test the moment it is submitted. Section 47(3) of the Act is explicit. The minister is not permitted to consider an application that is invalid. This means the delegate has no legal authority to look at Marcus's marriage or his child. In the eyes of the law, the compassionate factors in Step 2 cannot be used to fix a failure in Step 1. Marcus is currently at a legal dead end. Between Section 48 blocking new applications and Section 48A blocking another protection visa, there is no viable way for him to resolve his status from within Australia. The only remaining pathway involves a physical move, departing the Australian migration zone. By applying for an offshore partner visa, Subclass 309, Marcus is no longer subject to Section 48 or Schedule 3. Once applied from outside Australia, onshore barriers disappear. The application moves straight to assessment, where his genuine marriage and family ties are the primary criteria. In complex migration cases, the location of the applicant is often as important as the facts of the case. Because these rules are technical and subject to change, it is essential to consult with registered migration agents to evaluate a visa history before acting.